Let's ask Guji questions related to the elections. Foremost is, why are the names of the dead still found in the voters list? Or better yet, what is the procedure if a registered voter dies? Yes, there is a procedure to it, and that procedure is called cancellation of registration. Who cancels the registration? There is a collegial body composed of three persons that has the authority to cancel the registration of a person who dies, and that is the Election Registration Board, or the ERB. It is composed of the election officer as chair and as members the most senior public school official coming from the Department of Education, and also the local civil registrar. The ERB has the sole authority and jurisdiction to approve or disapprove application for registration, transfer, correction of entries, change of status, deactivation, and including cancellation of registration on the ground of death. What is the basis for the ERB to cancel a voter's registration because the voter already died? It could be any of these documents. Number one is a national list of deceased persons of voting age coming from the National Statistics Authority. And the other one is a certified list of deceased persons from the previous month submitted by the local civil registrar, or a sworn declaration of the next of kin who has personal knowledge of the fact of death and identity of the deceased. If none of these documents are presented to the ERB has no basis to cancel the registration of a person who is dead. So there could be instances where the fact of death is not reported to the LCR. And so the LCR or the NSA has nothing to report to the ERB. And if that happens, the ERB has no authority to cancel a voter's registration even if the person is already dead. There could also be an instance where the fact of death is not timely reported to the LCR. And if that happens, the LCR also cannot report to the ERB in time for its hearing to cancel the voter's registration. Or better yet, if the registered voter dies elsewhere, and that elsewhere is not necessarily the place of registration. If these incidents happen, it could give rise to the isolated incidents of dead persons remaining in the voters list. So it's not really that the Comelec resurrects the dead on election day so that another can vote using the name of the dead person. Another question is, if the candidate is not qualified, why does the Comelec still accept the Certificate of Candidacy, or the COC? The reason is because acceptance by the Comelec of the COC is ministerial in nature. What is ministerial in nature? It means that the Comelec, through its field officers or receiving officers, are only there to inquire into compliance with written formalities. What could be these written formalities? It could be, number one, we're going to ask, is the COC in the prescribed form? Because normally, the Comelec changes the prescribed form for the COC every elections. So we need to ensure whether or not the prescribed form used by the candidate is the prescribed form intended for the forthcoming elections where he presents as a candidate. Aside from that, we are going to inquire into the completeness of the COC, not only insofar as the entries are concerned, but also insofar as the attachments are concerned. In other words, if there could be a question in the COC that is not applicable to the candidate should not leave it blank. If that is not applicable to him or her, the candidate is mandated to state not applicable or NA, but never leave an entry blank. Otherwise, the field officer refuses or declines acceptance. Aside from the completeness of entries, we also need to inquire whether or not it is complete insofar as attachments are concerned. And one of them is the photograph of the candidate, taken within the last 6 months prior to the date of filing of the COC, and the documentary stamp stacks, and also, if applicable, the certificate of nomination and acceptance for a candidate running under a particular duly registered political party or coalition. Otherwise, if the candidate who claims to be under a duly registered political party coalition but does not attach a CONA, that candidate is going to be considered an independent candidate. Aside from that, we need also to check whether or not the COC is duly signed by the candidate. And if signed, is it duly notarized by a notary public or any person authorized by law to administer oath? These are the questions we need to verify before we accept the certificate of candidacy. But we never ask whether it's true, whether the candidate is really qualified. We do not ask into the truth or falsity of the written declarations in the COC. Otherwise, it ceases to be ministerial. It now delves into the substantive aspect of the COC over which the receiving officer has no jurisdiction to begin with. And finally, here's the question. Why are campaign materials all over the place when in fact it's not yet campaign period? People come to the Comelec and complain that the entire city or municipality, there is already a proliferation of campaign materials even if it's not yet campaign period. In one case, there was a candidate for vice mayor. After she filed her certificate of candidacy, she went around the municipality in a motorcade, probably waving to her supporters and announcing her candidacy. And that is already considered campaign or partisan political activity. And because of that, she was disqualified by the Comelec for premature campaign. But when the case went all the way up to the Supreme Court reminded the Comelec, what is the reason why you set the date or the period to file COC way earlier than usual? The reason is because you need more than sufficient time to print the official ballots where the names of the candidates are going to be printed on the face of the official ballots. If that is the premise, it means that the person who files his certificate of candidacy is not yet considered a candidate for the purpose of applying campaign rules and regulations. That person is also a candidate, is only a candidate for the purpose of ballot printing. If that is the premise, then anything that that person do or say to probably promote his candidacy that is not called premature campaign, we now call that freedom of expression. And because that is freedom of expression, the Comelec has no jurisdiction yet. The Comelec has jurisdiction only at the onset of campaign period. So now, as a people, are we powerless to even control the proliferation of campaign materials prior to campaign period, given the fact that the Comelec or the Supreme Court now calls that freedom of expression? Not necessarily, because if we are so bothered with the proliferation of these campaign materials, we can enforce local ordinances against littering, or better yet, civil code provisions on nuisance. So after all, we are not powerless, even if the question is not anymore about legality, but has now become a question of propriety. An informed electorate is indispensable in a democracy. But again, the usual disclaimer, the speaker expressed his views and opinions in his personal and professorial capacity. They do not in any way represent the views, opinions, and policies of the Comelec, where he works as Regional Election Attorney of Region 7. Assumptions made in any analysis do not reflect the position of the Comelec. That he is employed by the Comelec does not mean it endorses this channel or its contents. The Comelec does not represent or warrant the accuracy, applicability, and completeness of its contents and instructions. The Comelec likewise disclaims any liability to any party from any damage arising from direct or indirect use of the statements and instructions made by him. The contents are for informational and educational purposes only. Thank you.